Well, good afternoon, everyone. Welcome on behalf of the Dean and on behalf of the faculty as well. This is our second panel in our annual Law Review Symposium, and as its title suggests, this is a panel that provides a slightly different perspective, I think, from the others. The other panels I think you'll find have strategic or policy level focuses. This panel is going to focus instead on a lower level, on a tactical and operational level, but we'll be dealing with many of the same legal issues that you'll find discussed on the others. To do this, we have an eminently well-qualified group of panelists. I'll tell you a bit briefly about each of them and then hand things off to them. Our first panelist will be Major Frank Rosenblatt. Frank joins us from Fort Bliss, Texas, where he's a brigade legal advisor. Prior to his assignment at Fort Bliss, he served in Korea, in Bosnia, and in Iraq as well. And he took his JD from the University of Virginia Law School in 2006 and his LLM from the Judge Advocate General School in Charlottesville, Virginia in 2010. Frank will be followed by Captain Jeremy Schultes. Jeremy joins us from Joint Base Lewis McChord at Washington State. He was initially an infantry officer, but was picked up for the Army's funded legal education program. He attended law school at the University of Maryland and is currently assigned as a brigade judge advocate as well. Finally, we'll hear from Colonel Jeff Bavarnik. Jeff is currently the chair and professor of international law at the Judge Advocate General School in Charlottesville, Virginia. Colonel Bavarnik took his JD from New England School of Law and his LLM from the Judge Advocate General School, also in Charlottesville, Virginia. He's had a variety of assignments, primarily in the field of operational law. He has served in Iraq, at Fort Riley, Kansas, Fort Bragg, North Carolina, Iraq, and Afghanistan. We'll begin with Major Rosenblatt. Frank, they're all yours.
Thank you, Professor. It's great to be in Omaha, where people know how to pronounce my name. Lest I be confused with being an Army spokesman, I must start off with the standard disclaimer that I'm here presenting my own views, not those of the Army, and certainly not those of the Judge Advocate General's Corps. I'm going to start off with a montage here. We have some pictures of the most notorious and most press-covered cases that came out of Iraq and Afghanistan of soldier misconduct in the last decade. What all of these have in common is that these were serious incidents of battlefield misconduct that were all tried by courts-martial, and the courts-martial were all conducted in the United States. The paper that I wrote argues that our court-martial system was not effective in doing its stated mission and going around the world and being able to follow the troops wherever they go. When this happens, foreign civilians perceive foul play, and this tended to hurt our legitimacy and counterinsurgency efforts. I'd like to start with a story. There was an insurgent leader once who wrote an anger-laced list of complaints about a powerful foreign force that was occupying his country. He was upset at the crimes committed by this occupying force, but he was especially incensed by their practice of sending cases of misconduct and whisking them away back to the home country. For all he could tell, these crimes were then exonerated in what this insurgent leader termed to be mock trials. Well, this man was Thomas Jefferson, and those grievances are memorialized in the American Declaration of Independence. So what my paper and what my talk is about is, have we learned the lessons that really affected Mr. Jefferson as it's applying today, as we have a powerful military force that goes around the world? There's two brief things that you need to know. First of all, military procedure for courts-martial is very much like the criminal procedure for civilian trials. And what I did not know before I came into the JAG Corps is that there is no exception for this, for trials that are conducted overseas or even in the combat zone. The second thing you need to know is the concept of military venue. When cases of misconduct arise, they can be tried on site, or they can be sent away to another location at the convenience of the commander. Military doctrine expresses no preference for trying cases on site. What I found in my paper was starting with, I reviewed hundreds of after-action reviews from judge advocates and commanders who came back, and the bottom line of what I found is, starting with an after-action review from Colonel Blavarnik that I read in 2002, who said, wherever there are soldiers, there will be criminal misconduct. What I found was that these after-action reviews showed that it was very hard to stop a unit's combat duties in order to focus on the heavy demands required to conduct a court-martial. As a result, not that many were conducted. Instead, what usually happened was units would send cases of misconduct back to the home station in the United States. Sometimes they would grant leniency to combat crimes. There were courts-martial conducted in Iraq and Afghanistan, but most of these were guilty plea cases in which the accused waived a lot of important procedural rights in order to have their case heard, but to get themselves a better deal. In short, the presence of courts-martial in the combat zone was more a function of an accused cooperation with the government than it was about the impact of an offense on the military mission. Why were cases so hard? Well, as I said before, the same procedures apply. The requirement for the production of witnesses. So, for example, if you have a soldier who's accused of drug misconduct, it requires that court-martial conducted in Iraq or Afghanistan to bring in, based on the Sixth Amendment confrontation issues, the drug examiner from the United States Drug Lab in Atlanta. So as you can see, this becomes a complex interagency operation that takes a lot of time. All these courts-martial required the presence of judges, and so units, even out in those out in remote areas, had to wait until a judge could travel to their area and conduct a crime. And like other criminal proceedings, even in the middle of the combat zone, if someone wants to do a court-martial, a verbatim transcript of the proceedings must be prepared in order to aid appellate review. Courts-martial were very difficult in combat. And in addition to the normal requirements of courts-martial, the military has several other protections that go above and beyond. My paper looked at a couple of these, but two that I thought were interesting were the good soldier defense. If you have a client who's an employee at Home Depot and is charged with murder, he cannot claim that because he's a good Home Depot employee that he's therefore unlikely to have committed a crime. The military has an exception to this, the good soldier defense. And this allows a soldier accused of any crime, no matter what the evidence states, to bring character witness evidence to say that they were a good soldier. So a soldier in a slam dunk case in Afghanistan can request the presence of witnesses who the soldier went to basic training with a few years ago to say that he marches well and is generally a good soldier. This then requires the government to produce those witnesses and bring them to the combat zone for the trial. As you can see, these types of requirements will weigh heavily in a commander's analysis as to whether to conduct military justice in the combat zone. More likely, it's a lot easier to just send the case of misconduct away and whisk them back into the home country. My paper sums up by taking all of these after-action reviews, and I definitely noticed a trend, and I call this the Burger King theory of combat zone courts-martial. And this goes that sometimes the U.S. military is on bases that are so large, and it's basically like having a city with normal utilities and recreation opportunities, and you're not feeling like you're in a combat zone. And when you have these large bases, such as Camp Victory in Baghdad, there often tend to sprout up Burger Kings. There's that sort of sustainability that you can have a fast food franchise there. And I found that soldiers who served on Burger King bases were likely to be court-martialed for misconduct that they may commit there. However, those soldiers who were out on the many outposts and spread out far from these large, safe, garrison-style bases, their misconduct was not likely to be conducted by court-martial due to the difficulty of being away from airports and judges and all the things that make it convenient on a large base. For example, what the Burger King tells us, it wasn't until the 4th year of our presence in Afghanistan that we conducted a court-martial there. And that's because we didn't stand up a Burger King and expand Bagram Air Base until the 4th year. While the mission was austere, no courts-martial were conducted, regardless of the crime. They were all sent back to the United States. Similarly, Afghanistan then began to conduct court-martials until 2009, when the court-martial totaled, despite over 100,000 troops present in the country, there were only 11 courts-martialed. Why was this? Well, General Stanley McChrystal in 2009 put the emphasis on spreading out the force from these large, stable garrison-style bases and spreading the forces to 200 combat outposts. Incidentally, he also ordered that all Burger Kings in the country close as non-essential luxuries for the troops. Similarly, in Iraq in 2005, that year saw the temporary concentration of U.S. forces onto a large number of what are called super FOBs. And then the forces spread out after that. Well, in 2005, we saw a large spike in Iraq court-martial numbers. So right now you're probably asking, so what? We're not conducting courts-martial in Iraq or Afghanistan, or at least not as many as we should. But what I'll talk about now is the effect of this. A United Nations Special Rapporteur traveled to Afghanistan and studied the effect of our military justice system, and he had a lot of comments about how that was affecting our standing in that country and our ability to earn the legitimacy of the people in order to continue to wage that war. Here's what he found. During my visit to Afghanistan, I saw firsthand how the opacity of the American military justice system reduces confidence in the government's commitment to public accountability for illegal conduct. He goes on. The military justice system fails to provide ordinary people, including United States citizens and the families of Iraqi or Afghan victims, basic information on the status of investigations into civilian casualties or prosecutions resulting therefrom. Have we really learned the lessons from Mr. Jefferson? I submit to you that we have not, based on the last decade. This is problematic because in the last decade, based on the wartime requirements, we've brought in a number of risk factors into the force that will tend to imperil our counterinsurgency efforts unless they are met with a meaningful regime of sanction to deter misconduct. For example, several media reports have focused on the large number of gang members that are now present in the U.S. military. In 2007, 18% of enlistees to the military required a moral waiver for serious or minor convictions. And a medical study in 2008 of 2,000 Marines and soldiers noted that 10% of the 2,000 surveyed admitted that they had treated non-combatants, that they had damaged non-combatants or harassed or harmed non-combatants when it was not necessary to do so. Those are the risk factors. And what this also shows is the Burger King theory leads me to a concern that when we are on these large bases where we can conduct courts-martial, our soldiers' misconduct generally tends to only affect the other soldiers that are around them on this Burger King base. But you take those same soldiers and you move them to a remote outpost, the misconduct that they will commit has more of an effect on civilians. And paradoxically, that's the misconduct that is unlikely to be addressed by courts-martial. This is an interesting paradox that I came across after I had written the paper, but I'll let you read that. Sometimes the more you protect your force, the less secure you may be. And I have two pictures here. Basically on the left, you have how the U.S. military operated from about 2001 until 2006. And then on the right, the lessons we've learned about counterinsurgency from 2006 until present. The author of this doctrine, General Petraeus, you see him there on the right. He's not wearing his Kevlar or body armor. He doesn't have a lot of menacing armed guards surrounding him, but he's projecting the security of a Baghdad market that he's in by showing how he's comfortable with the people. On the left there, this first doctrine, basically protecting the troops and doing everything we can to do that. That's how we lived. We lived on large bases with built-up walls, machine gun outposts. Our vehicles drove down the center of the lane and violated all traffic laws because it was less likely that we would be shot that way, despite what civilians would think about that. But then in 2006, we showed that we were progressing, that we would follow civilian traffic laws, we would take off our body armor and drink chai with the locals, and that's what this is about. So the question that I started asking myself is, we have asked soldiers to give up a lot. We've asked them to leave the protection of their up-armored Humvees, leave the protection of their large bases, and get out with the people. So we've asked them to give up a lot, but have we judicially asked them to give up a lot? Paradoxically, It seems easier to ask a soldier to give up his rifle in a combat zone than it does to give up a lot of the constitutional protections that they enjoy and further protections that military courts have given them by courts-martial. But our inability to do this is one thing that causes doubts on our legitimacy when we cannot address it. We lose legitimacy when perceptions of military impunity foment among the local people. This slide shows tacit acknowledgement that we must play by the same rules if we are going to be perceived as legitimate. But however, at least as far as our soldiers retaining all their judicial rights that they had before, we're still going at it guns blazing and driving down the middle of the road at 60 miles an hour. So what I say we need to do is basically drop the constitutional rights that are traditionally thought to apply and really balance the rules. Balance mission accomplishment and the needs of that to promote legitimacy with rules of fundamental fairness that will affect the morale of the armed forces. So, does the Constitution apply to members in uniform? The answer to that question is unequivocally yes. In Article 1, Section 8, Clause 14, Congress shall make the rules for the government and regulation of the armed forces. This was a robust debate that happened in the middle of the 20th century about the application of the Constitution to the military, but it's now a lost debate, and conventional wisdom has taken over. For example, if you ask someone if they have a right to wear a T-shirt that disparages President Obama, they'd say, of course, you don't have that First Amendment right because you're in the military and you don't have that. However, the conventional wisdom is now saying that judicial rights under the Fourth and Fifth and Sixth Amendment, that those are sacrosanct and that they apply to soldiers. Well, is that really the case? The original practice suggests that it is not. For example, an Army officer in 1812 was convicted by a court-martial and dismissed. He sent his clemency matters up to the president to consider. In the clemency matters, he said that he had not been afforded his Sixth Amendment right of counsel, and therefore the court-martial should be overturned. The president was James Madison, who coincidentally wrote the Bill of Rights, including the Sixth Amendment. And President Madison was not persuaded. So this is presuming that he is following the line of Article 1, Section 8, Clause 14, that it's not the Bill of Rights, but it's Congress making rules for the special society of the military. Military courts have picked up on this. Much like ethics rules, protections for service members are a one-way ratcheting, only towards more protection. When the Supreme Court writes decisions like Crawford, they may be thinking of a crime lab in Baltimore and the reasonableness of that lab examiner being able to go to a criminal trial across town. And they've never said it applies to the military to require the production of such expert witnesses halfway across the world. But military courts have picked up on this, and every time there's a major Supreme Court case on the Fourth, Fifth, or Sixth Amendment, it's instantly applied to the military. What this is really picking up on World War II and a lot of the shock that millions of Americans saw with the system of summary justice that was conducted then, continued after the Vietnam War, where there was allegations of racism in the application of military justice, to the present day, where the debate has long died down about the true application of constitutional rights to service members. But I submit that if we are to be successful in our national military efforts and promote legitimacy of our force around the world, this is a debate that we must continue to have. Thank you.
In any event, I'm Jeremy. Thanks for everyone being here today. I have the same disclaimer that Major Rosenblatt had. Everything that I talk about today, everything that's written in my article that you'll see forthcoming in the next few months is purely my perception and my representation. It is not that of Fort Lewis and First Corps. It's not that of the JAG Corps, and it certainly is not that of the Army in general. All right, so I'm going to talk about rule of law. This is my agenda slide. This is also my closure slide. What I want you to focus on here is really the three elements there along the bottom. The synergistic interagency team, ends-based holistic approach, That's the approach that we use in theater. And then the effects-based assessment. I'm going to go through a couple of slides giving a little bit of background for rule of law, because I'm not sure how many of you all here are familiar with rule of law, particularly in a foreign country. Okay, so here's the definition that we worked with while I was in Basra. That's the southernmost province in Iraq. I was there with my unit, 17th Fires Brigade, from July of 2009 to July of 2010. The thing that's important about this definition is this was the starting point. This is what everyone was using across theater. This is actually the UN's definition of rule of law. It was adopted by the United States in general, the Department of State in particular, in the early 2000s, and then about 2005, this definition is what the Department of Defense incorporated into its doctrine, and this is what we were using in our field manual while we were downrange. All right, so wheel of law, wheel. That wheel that I showed you is not... that doesn't come out of our doctrine, doesn't come out of our field manuals or anything like that. We worked in Iraq under the Joint Campaign Plan, the JCP. And for rule of law, Department of State is lead, which is what you would expect. Civilians are in lead for development of rule of law capacity in failed states and post-conflict states. The military is kind of second bench, or we're in support. So the JCP is what set up the rule of law conditions. We've got the embassy and the multinational Corps Iraq, multinational Corps Iraq and multinational Force Iraq. Those were the two highest levels in theater who jointly developed the JCP. Within the JCP, the Joint Campaign Plan, there are 4 what are called lines of operation. And the only thing that's important about that is those are our 4 big focus points. Anything that a service member is doing or an ambassador is doing in Iraq in that period, for my concern, 2009-2010, had to be somehow connected to those 4 LOOs, lines of operation. My line of operation was the 3rd one, rule of law. And within the rule of law, there were 6 conditions that we wanted to develop. And the 6 conditions were the spokes on that wheel that I'll turn you back to again in a moment. It was the 6 C's, the most important of which were courts, cops, and corrections. And then we also looked at corruption detection and commercial rights and property rights. And then we were also concerned with development of the legal community in general. So those were the spokes, and they all came together in the center to develop what I was referring to as the hub. And that is the final recognition of, by the local population, the recognition of the rule of law, the belief in it, and ultimately conformity with rule of law. And that's everybody, the government and, of course, individuals. So I told you to pay attention real quick to the bottom of the first slide. I want to talk first about who. I mentioned briefly that Department of State was in the lead. And that's true, which is why you see so many well, you see Department of State first, then you see all these other departments and agencies that are up there. Civilians were in the lead for rule of law. Then came Department of Defense, and that was my team represented down in Basra Province. So you've got the entire country, and in each province you have a provincial reconstruction team called a PRT. Our PRT in Basra consists of about 90 people, and the rule of law portion in particular was led by Department of Justice, former Assistant United States Attorney from San Francisco, Dave Hall. So he came with 35 plus years of experience, in particular trying cases, which will become important here in a moment. He was supported by 2 contractors who were very experienced defense attorneys, Tom Doherty and Dan Connell, and then also a BBA, a bilingual bicultural advisor. He was a translator, he was an interpreter, and most important, he understood the values and the norms of the culture in which we were working, which is absolutely imperative for us to understand to be able to help them develop their rule of law, not swoop in from the United States and simply incorporate or put in place what we think the rule of law should look like there. He was Iraqi-born, Iraqi-raised. He was an attorney. and he absolutely loved Iraq, so it was great to have him on the team. On the military side, we had, I was the rule of law team lead, and then I had 2 paralegals who worked for me, 2 enlisted soldiers, a male and a female, and then I also had an interpreter, and I had a LEP, a law enforcement professional, who was a retired federal agent and was assisting me in case packet development and working with the Iraqi police. So all of us came together to collaborate on how we were going to go about rule of law. So how are we going to do it? Well, it's going to be this end-based, holistic approach. The ends are basically the big goals. For us, they were the conditions. We wanted to set these 6 conditions, the 6 C's that are on the wheel, the spokes of the wheel, because if we don't set those conditions, we can't get to rule of law. And depending on what province you're in and what level of security there is in that province, that will drive which one of the 6 C's you can focus on. So pretty much in every province, we were looking at cops, courts, and corrections because they were some of the most fundamental players, the players that are within those conditions, in each of the provinces. They were just fundamental for law to work. And then, of course, the others were, I shouldn't probably refer to them as niceties, but it was if you had enough development in your province, then you could move on and focus more on some of the civil law issues and developing law schools and developing the Iraqi Jurist Union, the Iraqi Bar Association, and focusing on those property rights. All right, so the second bullet there, I'm just highlighting again the need to understand the environment in which you're working. We made mistakes early on with coming in and trying to just put in place what we thought should be there, and fortunately we learned significantly from our mistakes. So I did a lot of preparation before I went over there, learning about the law that's in place there and understanding the environment in which I was going to work. And then finally, you have to be prepared to adjust fire. You know, as the boat's going downstream, you have to watch the course that you're on to make sure you don't run into the shore. And it was really important for us as we went along, as we developed the projects that we wanted to work on, to meet the objectives that we had to attain in order to build those conditions, the 6 conditions on the rule of law. It was really important that we identified when things weren't working. When we were trying to get ahead of the power curve and the province wasn't ready, or when we were dragging behind and actually our host nation partners were ready to move a little bit faster. And we had to be doing that over and over and over again. Otherwise, we were wasting resources, we were wasting time and money, and we were frustrating actually development of rule of law capability in the province. All right, so we're back to the wheel. Those are the 6 conditions there. Essentially, there's a whole bunch of words that go with those other 6 conditions, but the bottom line is really 2 things. One, we were trying to develop skill sets, skill capabilities in each one of these areas. The judiciary, helping them to develop, which my illustration is going to be about, a focus on scientific and technical evidence. Because in Iraq, and certainly they're not the only country, but for my purposes, in Iraq, the judges, the investigative judges who were sitting listening to criminal cases, they had this interesting, one judge told me one day, I said, well, why is it that in Iraq, you guys just focus on the confession? What they were really focused on was the confession from the accused or from the defendant, and then they wanted, ideally, 2 witnesses. Well, I mean, y'all have gone through criminal law, and you know frequently there aren't witnesses to crimes, and many times you're not going to get a confession, or you're going to get a partial confession. Well, what that led to, which many of you have probably heard about, is situations where if you can't get a confession, you just got to work a little harder to get that confession. And sometimes a little, blunt force trauma will facilitate that process. And then lo and behold, you've got a confession. So now we can go ahead and convict them. And what we were saying is, whoa. Take a couple steps back. In our courts in the United States, one of the things that we're really focused on, too, is circumstantial evidence. There's a way to look out, which might come from a witness, but also might come from some other sort of evidence. It might be that you have fingerprints somewhere. In some circumstantial direct, you might have fingerprints somewhere. You might have telephones or computers that are seized on an objective or at a crime scene, and we're able to pull data from that. There might be documents that are found there. There might be, in Iraq, we were frequently concerned with IEDs and other sorts of explosions. So what about the materials that were found? Maybe some of those materials came from same lot numbers that were either smuggled in, which might be hard to track, but we might have picked up on other objectives, or might have come from actually imported products. And then we can track back and find out. So there was a whole lot more to look at, and the judges weren't so interested in it. The judge told me one of the first days I was out, hey, look, I can look at a guy, and between his ears and through his eyes, I can tell if he's telling the truth. I mean, that's rough translation, of course. I had my translator helping me out. We weren't speaking in English. But, okay, in some sense, that makes total sense, right? I mean, we do the same thing in our courts. There's a sense of credibility. We look and we listen and we pay attention and we look at the surrounding circumstances and what corroborates. And then from that, we're able to ascertain, or the trier fact is, whether that person's telling the truth. So it kind of makes sense. The problem is, if that's the only thing you're looking at, it makes it really hard to either exonerate someone sometimes or effectively prosecute them. All right, so from all these conditions right now, I want to provide you an illustration. I want to focus on judiciary and law enforcement, condition 1 and 2. So in the sense, what I'm talking about here with the evidence, I'm going to introduce you to 5 players. We've got the Iraqi police. Those are the guys who are the beat cops. They're out there, they're walking around, they're reporting to a scene of a crime. Then you've got the crime scene technicians. Those are the guys who go out, and gals, and they actually collect the evidence. And then you've got the investigative officers. Those are the sleuths who go out and they chase down leads, and they are supposed to work with the crime scene technicians, but in Iraq frequently weren't. Those are the guys who are building the case. Then there's the criminal laboratory technicians. Those are the people back at a lab who are exploiting all of the evidence that comes in, pulling the prints, checking the ballistics, all that kind of stuff. And then finally, there's the investigative judges. Now, there's this interesting thing in Iraq where the investigative judges they work closely with the investigative officers. So these first 4 people I talked about, the investigative police, the investigating officers, the crime scene technicians, and the lab technicians, they all work under the Ministry of Interior. So they're all in this kind of police section. And then, under the Higher Juridical Council, we've got the judges. But the investigating officers work at the direction of the investigating judges. So the judges aren't this neutral, detached magistrate who's sitting up at the bench, and the prosecutor comes in and puts on his case, and the defense attorney comes in and she puts on her case, and then the judge listens to everything, and if he's the trier of fact, applies the facts of the law, and there we go. There, the judge is directing the investigator to go out and do certain things. And then the prosecutor comes in, the prosecutor just makes sure procedures followed. And then the accused or the defendant may or may not have an attorney. He should have an attorney, but their public defender system didn't work very well. And he's in there and he's just along for the ride and hoping that he doesn't spend too many years in prison before he actually gets to a court date. Okay, so we've got these 5 players. When we were talking about bringing in all of this type of evidence, the technical evidence, one way that we were able to approach development of rule of law capacity was to bring our interagency team together, which included military and civilians, and start training our host nation partners. So on the military side, we had military police, and they had some civilian trainers who were working with the local policemen, these IPs that I talked about. So they were training them in their stovepipe to go out and learn how to secure crime scenes, right? Because if they don't effectively secure the crime scene, then we don't have good evidence. We want to keep people out, evidence in. Then we also had those same military police and civilian trainers, IP as they were called, International Police Assistance folks. Those guys were also training the investigating officers how to develop leads and how to develop a case file. Then we also had military police working with the crime scene technicians. But they were working with each of these folks in stovepipes, each of these populations of players in stovepipes. And they weren't having them talk to each other. They weren't having the police and the crime scene technicians and the investigating officers work together. And that was really one of the second concerns that we had, not just capacity building, the skill building, but also developing partnerships between our host nation directorates. All right, so it was very important from my perspective to start getting these people together so we could have this synergistic effect where when we contributed time and money, all these resources, that we could bring these guys together and develop their skill as efficiently as possible. So what we started to do was bring in the crime scene technicians and the Iraqi police, and then we would bring in the investigative officers, and we would have the crime scene technicians actually train the Iraqi police and the investigative officers, instead of having uniformed personnel do it. So we started doing a sort of train-the-trainer technique, where we would train the technicians and train the IOs, and they would train your sort of beat cops who were out there. So they were all talking together and understanding. And then we started bringing in, a couple months later, when we did the assessment that they were ready to move forward, we started bringing in the crime lab technicians, because we wanted the guys who were out on the street to understand the evidence that they were collecting and how it would be exploited and how that exploitation would then help the court process. And at the same time as they're coming down and teaching each other and learning together and learning from our specialists who would come in, they're developing their teamwork. And in the case of Basra, we had 12 different districts, district headquarters. So what we would do is we'd make sure that when we did these training programs, we would bring in the police, the investigating officers, the crime scene technicians, all from the same districts, because those were the guys who would be working together out in the field. They didn't have any sort of continuing education once they left the police college or police academy, so it was really important to start developing these training programs within each of their districts. Then there was finally the judges, right? We can collect all this stuff up, we can exploit it as well as we want, but if the judges aren't on board, and believe you me, the judges in Iraq were very skeptical of parting ways from what their criminal procedure code there required of them, which is understandable. So what we started doing is I would go out with case files. I would take case files from a site that we went to that was exploited jointly by military, U.S. military, and by Iraqi Army or Iraqi police. The evidence was collected. We would bring it back. We had folks who would exploit the documents, would pull down the digital media from the phones and all that kind of stuff and the computers. We would develop reports. Then I had a section that would translate all of that into Arabic. We would make sure that it was not in a classified status. So there was a lot of information that was pulled out of it. And I would take all of that information out, as well as any interrogations or interviews that the U.S. forces had conducted. We would have that also declassified, translated into Arabic, and I would take all these case packets out to the judges. And then I'd start explaining to the judge along with my law enforcement professional to get them to understand how they could use that. Then we took the judges to the crime lab, because the judges said, hey, look, that's all nice that you're out here telling us about this stuff, but we don't have the capacity to do this. And I said, well, actually, we do have the capacity to do this. So let's go to the crime lab. So I got Chief Judge Kazel, who was in charge of all 90 judges in the province, to go to the crime lab with us. And the crime lab technicians, under the leadership of the one-star general there that was in charge of everything, put on a presentation for them across a span of 5 days to talk about all of the capacity that they had, the reports that they generated, how to read those reports, how they would come to court to talk about those reports. Reports that the judges previously had just taken and said, I don't know what this is, I don't know why this is in here, I only take confessions and talk to witnesses, and threw it in the trash. Okay? So the judges are now finding out, holy cow, we have the capacity to actually do a lot of this stuff. And in some cases, like pulling information out of cell phones and laptops, they did not have the capacity to do that, but we brought in our technicians to show them how to do it with some of the material that, some of the devices we had, and then we were also purchasing those devices for them. So anyways, it's I need to wrap it up, I'm almost out of time, but this is just one illustration of how every day when we went out, our civilian and military interagency team would go out and engage in partnerships and would start projects that we hoped would have synergistic effects across all of these different populations, folks who were involved in each one of these conditions who needed us to help build their capacity and help foster partnerships between them. So in any event, I hope you learned a little something about rule of law. I hope also I could bring a little good news story home for you. Where that goes in the future, anybody knows that hub at the middle, that's not something that happened across 1 year of time. That'll take years, if not decades, to actually get to a point where all of these partners are accepting that and the public accepts it. All right? So thanks for coming. Appreciate it.
All right. Well, first thing I want to say is a special welcome to an old friend. We actually got a few in the audience, but we have a former staff judge advocate for the 82nd Airborne Division in the room. First judge advocate lawyer to ever jump into combat. It's Colonel retired Jim Smith back here. An old friend, a judge. He saw me probably about 15 years ago in court, and maybe I'll see if he had any good in our Bridging the Gap sessions. But I want to welcome Judge Smith. Amazing. A couple other colleagues in the room, former judge advocates you'll hear from later, Professor Korn and Professor Vic Hansen back there, so great to see some old friends. Also, thank you very much to Jordan Clemente and the Law Review and Creighton and Professor Watts for inviting us here. On behalf of all the judge advocates, it's a real privilege to come here and speak with you. I think one of the important things for lawyers in the military, meeting with students, and I'm sure there's other folks that have served, and I met one that's served in the reserves or still in the reserves now, is to kind of hear that military perspective. You have all the stuff that you hear about in law school, the stuff you read about, see on the news, but there's great judge advocates like you heard from Jeremy and Frank, and you can hear from Major Newhouser later as well, that are out there on the front lines just doing amazing stuff. So to hear the military perspective of what lawyers do in the field, I think it's very important for the civilian community to get a sense of that. But what I'm going to talk to you for today, about 20 minutes or so, is due process for detainees in the combat zone. For all that you've heard and read about Guantanamo Bay, that's a separate paradigm. And so detainees taken from the combat zone early on, you all recall, after September 11th, pretty much from October of 01 all the way through September of 2004, detainees were pulled from Afghanistan and sent to Guantanamo Bay if they had a strategic intelligence value. So all of that litigation is specific to the detainees that are at Gitmo. All those cases that went to the Supreme Court, starting with Hamdi and Rasul, through Hamdan and Boumediene. Okay, that's Guantanamo Bay. What I'm going to talk to you about is a concept of due process for detainees on the battlefield. How much is too much? How much is too little? Think about the concept of indefinite detention, right? Somebody that's over in Afghanistan, pulled from the battlefield, under a law of war concept, right? And I'll just drop back for a second here and remind you of the legal basis to detain. So early on, so September 14th of 2001, you all recall Congress passed the authorization for use of military force. But then on September 18th, 2001, the president signed into law. So the legal basis to pull somebody, actually at the time, interestingly enough, that's to go target. To basically go after the enemy, anybody that's in Al-Qaeda, the Taliban, or associated forces, to go and target them on the battlefield. Well, the Supreme Court in Hamdi in 2004 acknowledged that it doesn't mean you can just go kill people on the battlefield. Justice O'Connor said part and parcel of that is you're going to take detainees. And that's been the long practice throughout the history of war, is not killing everybody in battle, but taking detainees. Now, the one difference with September 11th and the early on the conflict in Afghanistan, detainees that are pulled in, the president made a determination. So unlike some past conflicts, and again, I won't get too much in specifics, but Common Article 2, International Armed Conflict, and Article 5, Tribunal to determine if someone's a prisoner of war. So early on in Afghanistan, you have a Common Article 2 conflict, but President Bush said, we are not going to afford POW status to Al-Qaeda and to the Taliban for that matter as well. So there's going to be no Article 5 tribunals. So now, I throw out some things to think about, perhaps if you have questions on this. So now, what is the status of these detainees in Afghanistan? They're not POWs. We're going to hold them to the end of hostilities. Well, when does hostilities end in the war on terror? It could be never. So you have this concept now of indefinite detention. And so what's the process, the substantive and procedural due process that should be afforded to a battlefield detainee? Not Gitmo. Forget about Guantanamo Bay detainees. There are those that are still in Afghanistan now. I would submit to you that between October of 2001, I say October because if you recall, that's when the 5th Special Forces went in, right? The air war started on October 5th, October 19th. The 5th Special Forces Group out of Fort Campbell, Kentucky went in with the Northern Alliance basically and essentially defeated the Taliban over the course of a few months. So these detainees are pulled in, okay? And what process are they afforded? It's either you go to Guantanamo Bay or you're staying here. You heard a couple references to Bagram. The Bagram Collection Point was the first major detention facility. That changed its name to the Bagram Theater Internment Facility, or BIDF. Now there's a new $60 million facility in Afghanistan called the Detention Facility in Parwan, the DFIP. That's where the detainees are. Some of them, oh, by the way, have been there for 5 or 6 years. Okay? So I'd submit to you is from about, say, May of '02 when that facility opened to July of '09, detainees in Afghanistan had essentially no process. And that was a strategic liability for the United States. Make no mistake about it. Okay? There doesn't have to be any disclaimer for me standing here to tell you that it was a strategic liability. And other nations wanted nothing to do with detention operations, nothing at all, because it's essentially a black hole. The United States would pull detainees off the battlefield, had every lawful right to do that under the Authorization for Use of Military Force. By the way, the new administration dropped the Article 2 executive power. So early on, the legal basis included the authorization for use of military force and then the president's authority under Article 2 of the Constitution. The new administration just goes with the authorization for use of military force, a document from September 18th of '01. Okay, so these are law of war detentions. Now, what process? Early on, and for those first 6.5 years, essentially no process. You'd gather in a room, an intelligence analyst would come in and say that this detainee's a bad person, they committed some bad acts, and we can't release them back to the battlefield. A number of folks would sit around, and if you agreed with the intelligence analyst, okay, great. Again, some up until September of '04 went to Guantanamo Bay, but other than that, they would stay. The board would discuss it, and the commander would decide. Sometimes you had the wrong person, few and far in between, and they'd get released. But other than that, the default, if you did not go to Guantanamo Bay, is you just stayed in the facility. And so essentially no process, and that's a strategic liability for the United States, why many other nations wanted nothing to do with detention operations. But in July of '09, so President Obama comes in, January of '09, orders a special detainee task force to look at detention operations in Afghanistan. And by July of '09, the Secretary of Defense put forth a new policy for detainee review boards in Afghanistan. So to show how far we've come, where detainees would essentially have no process, the detainees may not even know they had a board. Think about some of the processes that we know and understand. Here's the other thing I want to mention. We're not going to overlay the U.S. system of due process on this. Absolutely not. This is battlefield detention. Soldiers are in harm's way, going out to pick up these detainees. They are not going to get the same rights. And some of you may ask questions about this and dispute this, but I'd submit to you, detainees on the battlefield are not going to get the same rights that a U.S. citizen gets. Certainly if there's 1 or 2 U.S. citizens that have joined the bad guys, absolutely, as we saw with a couple cases. But the bottom line is a detainee, an Afghan citizen, or whether it's Yemeni, whatever it may be, they're not going to get the U.S. constitutional due process norms. So what do they get? So in July of '09, the SecDef's new policy set forth some of the basics. You think back to some customary international law principles, some human rights principles. Just notice that you're being held and why. Not that you're being held, you know you're being held, but notice of why you're being held, an opportunity to be heard before an impartial trier of fact, and perhaps to have a representative. I think under customary international law, you'll kind of see those 4. The 4th one's interesting, a representative. Is it a legal representative? You can debate that. Okay, but an opportunity to be heard. Early on in Afghanistan, in this '02 time frame, sitting on a detention review board, the detainees wouldn't even know that they were going before a board. They would have no idea that they were, and if the board decided to keep them, well, they'd know by default because they're still there. They wouldn't even be informed that their board met on their behalf. The first time a detainee ever appeared before a board was in April of 2008. And the detainee would come into the room before the board, and the board president would ask if they had any questions, yes or no, whatever they may say. They probably have no idea why they were in the room, and then they would leave the room, and that would be it. But in the policy I mentioned, July of '09, these new detainee review boards, there's a board of officers, not judge advocates, so line officers, as we say, basically anyone but a JAG, not lawyers. 3 of them will sit, and by a majority, so 2 out of 3 are going to have to determine, is the detainee affiliated with or in the Taliban or Al-Qaeda or associated forces, or have they committed a belligerent act against U.S. or coalition forces? That's the criteria. It goes all the way back to that authorization for use of military force. 2 out of 3 will determine by a preponderance of the evidence if the detainee meets that status, that criteria. The evidence is presented by a judge advocate who's a recorder in a neutral fashion, not a prosecutor, and not like a government representative as we would think of that, but just as a neutral person, a judge advocate, because they're best capable as lawyers, we all know, to basically present information in a clear, concise manner to this board. And so here's what the detainee did. By the way, the detainee's in the room. Okay, so they've been informed of that the board's coming up 60 days after capture, 6 months thereafter. They're in the room. They hear all the unclassified evidence. Say that again, unclassified evidence. They are not going to be in the room for the classified portion. Okay? Then the board members can ask the detainee questions. The detainee can respond to the unclassified information that they've heard. The detainee can have live Afghan witnesses in the room. They can testify on their behalf. You heard a little bit about from Major Rosenblatt, that good soldier defense. They absolutely, I mean, it's not that, but they can have the tribal elder come in and say, you know, number one is they can say, well, the person didn't do this, or I'll basically vouch for this detainee. Okay, so they can have witnesses, notice opportunity to be heard, impartial board. Now some may say, well, it's the military. How can it be impartial? It's the people on the battlefield that captured them. Well, I'd submit to you that the best system in the world, which you heard about from Major Rosenblatt, he was talking about how the UCMJ and court martials apply overseas. But I'd submit to you, no one can really dispute that the best system in the world is the UCMJ and a court martial that takes place in the States and perhaps overseas as well. But a court martial affords soldiers, I mean, you all know that Miranda came out in '66, you know, informed the accused of the constitutional rights that he got in 1787 and 1791, right? Let him know. Well, the UCMJ in 1950 is when investigators in the military, 16 years before their civilian counterparts in law enforcement, had to inform an accused of their rights. And so the UCMJ is a great, great system, right? But so those aren't the rights, though, that we're going to apply to these detainees overseas. And so the detainee has the opportunity to be heard. He doesn't have a lawyer. That's another key point. Some may ask, well, why doesn't the detainee have a lawyer? He has a personal representative, a non-lawyer, to represent their best interests. Okay? So the lawyer can see the non-lawyer, the personal representative, is allowed to see the classified evidence. So even though the detainee can't see the classified evidence and have an opportunity to present the case, their representative can. So these are some of the rights now that the United States have implemented since July of '09, so going on about 18 months, coming up on 2 years, for detainees in Afghanistan. How much time have we got? A few minutes? What I want to talk about now is, and then please, any questions that you have later about these detainee review board process, is what does the board determine? Number one is, do they meet that criteria? If they don't, by a preponderance of the evidence, okay, they get released. Now, it's a low percentage now, about 11% or so is kind of the average. The second determination would be if they meet criteria, they're going to stay in the facility, they'll get another board in 6 months. But the third thing, and this is kind of a new area I'd like to talk about, I didn't address in an article that I wrote, is the transfer to the Afghan authorities for prosecution. You heard a little bit about Iraq, and Iraq there's some interesting times working with the judges there as well. And there's certainly days where you don't know whether to laugh or cry. It's frustrating. You got bribery, fraud, and corruption that we're just not used to in our society, but it's really part of their society. Same thing in Afghanistan. Okay, so now you're sitting on a board, and the detainee is either part of the Taliban or Al-Qaeda, maybe part of a network, or they've committed a belligerent act. And there's this term, accidental guerrilla, from a Kilcullen book. This person who, because of the circumstances of where they live, will take $5 or $10 to go out and shoot at the coalition. Okay? And so accidental guerrilla because of where they are in their life, the Taliban's in their area. Okay, so now this person's in detention. And the review board has to determine, do we want to keep this person in for another 6 months, or should we transfer him now to the host nation for prosecution? Because that's where Iraq went after the security agreement, January 1st of 2009. Essentially understanding that all of the Iraqi detainees in coalition custody, primarily the U.S., right, they're going to be handed over to the Iraqis for prosecution. There's going to be some really bad guys, Al-Qaeda, Iraq, Jaish al-Mahdi. There's going to be some of those organizations and elements that we're probably not going to turn over, but that's a decision way above any level in here. But for the most part, you're going to have a lot of individuals that are going to be turned over to the Iraqi government for prosecution, and that's all started. But let's move over to Afghanistan, what we've been talking about. So these accidental guerrillas, is that the case that you want to hand over to the Afghan officials to prosecute? Because, oh, by the way, when he gets out, you know, the other thing I mentioned, Justice O'Connor from the Hamdi decision, saying that detention is part and parcel of this authorization for use of military force. She was pretty clear in saying that it doesn't mean indefinite detention. But the other thing she said was, you got to take them off the battlefield so they're not out there. Again, this is all self-evident, that they're not out there shooting at our soldiers again and killing them. Of course you're going to pull them off the battlefield. The accidental guerrilla who gets paid $5, if you don't have confidence in the Afghan prosecution system and the person's going to get released, they're going to be right back out there shooting our soldiers. So I'm going to throw out this other idea for a second to think about. Maybe I have a question on it is, what if the detention paradigm, either through the detention review boards, has so much process, like you're thinking about the U.S. system, collection of evidence, providing this to the detainee review board, that it's so difficult to keep someone in that they're going to get released back to the battle space? Or you transfer them to an Afghan criminal justice system, which is in its early stages, and where they're going to release the detainees. Okay? What is that going to do to the battle space, to the operations? What's a commander going to do when he picks up someone he knows is a bad guy? Don't worry about, you know, evidence and this. He knows that this guy shot at his soldiers. This guy was laying an IED. Sorry my soldiers weren't FBI investigators and collect up all this evidence against him. I know he was doing this. He sees that detainee back in his battle space, taking up arms again or laying an IED. Is the commander going to capture that person again and put him back into that system? You know, so think about that. If the system is too difficult, what's that going to do to releases? If the Afghan criminal justice system isn't what we would expect in the U.S., and detainees are getting released after we transfer them to the Afghan system for prosecution, they get, say, time served because they've been in the DFIP for 4 years, right? Or we don't have the evidence. And so it's difficult. These are difficult things that the lawyers on the ground grapple with every day, that the line officers who are charged with making determinations, should we keep this person detained? Should we transfer him to the Afghans? And so it's a system that early on, where there was no system review, absolute strategic liability. But now there's legitimacy in the system such that human rights organizations and the ICRC are very comfortable with the process with 2 exceptions. They absolutely don't like the fact that the detainee can't see the classified evidence, and that's, I would submit to you, that's probably not going to happen. But their personal representative absolutely can. Okay, think about it. There's many defense counsel in the room, and certainly all these great young law students understand that concept, that the lawyer is the one that's going to dig into the evidence. It's not going to be your client. Your client's going to help you and all that. The detainees are not going to see the classified evidence, but their representative can. And the second piece is lawyers. Okay? The detainees are not going to get a lawyer. That's a government policy decision, and the ICRC and human rights organizations say they should get a lawyer to represent them, but they're not going to. Certainly when those detainees at Guantanamo do, but those on the battlefield are not going to get a lawyer. The U.S. military simply can't support every single person getting a lawyer. The other thing, too, is think about the precedent it may set. You know, you talk about customary international law. If the United States starts giving lawyers for detainees, thank you. It's a concept that spurs a lot of debate, and we'd love to discuss it if you have questions on that. So essentially what we talked about really is due process for detainees. It was a liability for the United States, but we've come a long way with the policy from July of '09. And the new phase of this is who are we going to transfer to the Afghan government for prosecution, such that there's a comfort level of commanders on the battlefield that that person's not going to end up back in their battle space because of bribery, fraud, and corruption that may be within the Afghan system, similar to what we saw in Iraq. But with that, I think we're going to turn it over to the group for questions, so thank you.
Well, thank you, gentlemen. And true to their profession, our panelists have all come in under time and leaving us opportunities for questions here. I thought to begin that we might take a multinational turn. Understanding that the U.S. Armed Forces seem not to go anywhere unilaterally any longer, that we're often parts of coalitions. Do the experience base of our partners in these coalitions offer any solutions to the issues that you spoke of today? For instance, Major Rosenblatt, do the military justice systems of our coalition partners offer any solutions to the issues that you raised? Captain Schultes, are we really leveraging the experience, particularly the experience of coalition partners that have experience with civil law systems? Are we leveraging that experience base in our rule of law operations? Are these really U.S. go-it-alone type missions? And then finally, Colonel Bavarnik, are our coalition partners shaping our detention policy and the process that we provide to detainees on the battlefield? Or more importantly, should they? Should those coalition partners have a say in that detention policy? Major Rosenblatt?
I think the U.S. has a lot to learn from the emphasis on on-site justice that other countries are placing. For example, the United Nations coalition in the Democratic Republic of Congo in 2003, there were a lot of allegations of rape and sexual assault, and the soldiers from the peacekeeping force whisked back home. And so there was a strong push then for mandated legislation to do on-site justice when possible. Similarly, the British had a detainee abuse incident with Baha Musa from Basra, Iraq, a few years ago, and they set up a public inquiry with proceedings in the affected language, Arabic, so that it could be followed back home. They seem to be attuned to the possibility that other people could assume exoneration when it's not in the native language, or they could be just reflecting on the lessons they learned from Mr. Jefferson.
Thanks.
The answer to your question, sir, is they should and they do. So downrange all across Iraq, and I am not as well versed in Afghanistan, but I believe it's the same situation there. Not only do we have the interagency all on the United States side, but in particular, European countries are participating. The UNDP is a significant contributor. Also down, so they were down frequently working on computer programs with us, and so Tom and Dan and Dave, the civilians from the PRT, the Provincial Reconstruction Team, they were working with the UNDP folks. We had the Japanese who were providing resources for community policing efforts, and we were building new district headquarter buildings with that Japanese money, and with sending some of our Iraqi Ministry of Interior folks actually to Japan for training. We were sending judges to Jordan for training there as well. So there were a lot of different folks from around the world who were either providing money, or were sending folks into theater, or were setting up systems in their home countries for the Iraqis to go to for training.
Sir?
Yeah, so the question was about coalition involvement with detention ops and whether or not they should have a say in how we conduct or shape our operations for detention. And this early period of time that I mentioned, there was essentially no coalition involvement because they saw the liability and how the U.S. was handling detention operations, and so there was minimal effort. I recall one time in '02 when the Italians, the first who sent the first combat forces. There were other nations involved. Absolutely, the coalition involvement in OEF early on. Many nations contributed troops to the effort early on in Afghanistan. However, the first nation that sent combat troops were the Italians, and when they captured a detainee, they had to come to the U.S. detention facility because they didn't have the capability. And so those problems started out early on where the U.S., and you know, one of the people that were there, of course, implementing policy from up higher was, no, you can't even come into this facility to see your detainee, so to speak, the person you captured. They're going to fall under the U.S. paradigm. And so it was the U.S. and the way we were treating our coalition partners and detainees they captured, they kept everybody at an arm's length. That's all changed, though. All of that's changed. Let me make one other point here. You've all heard of ISAF, the International Security Assistance Force. The majority of U.S. troops deployed now fall under an ISAF paradigm. Only a few still remain under the OEF, or Operation Enduring Freedom paradigm. And all the detainees I always mentioned that are held in the detention facility in Palawan and Bagram, Afghanistan, are U.S. captures under the OEF, or Law of Armed Conflict basis. ISAF, including the U.S. forces that work under ISAF, which includes all the other coalition nations, cannot send detainees to the detention facility in Palawan. They cannot keep detainees. They have to turn them over to the Afghan authorities within 96 hours. And so to the extent that the coalition partners are involved in detention operations, absolutely, those that have combat troops can capture folks on the battlefield, but they turn them over to the Afghan authorities right away. And so the answer to the question is, should they help shape the policy? Absolutely, with under ISAF paradigm. Each nation has its own caveats, but certainly not when the U.S. is still out there as the main service or main nation sending troops into harm's way to go capture the bad guys. That's going to be under the U.S. paradigm.
Thank you.
I would be absolutely remiss if I didn't mention the British contribution, particularly in Basra province. The British were in Basra province exclusively from 2003 until early 2009. That's when we first sent United States Division Headquarters down there, and actually the unit that Major Rosenblatt is in now, they came in and they were working in that area, as well as a unit out of Fort Carson, and then we came in and backfilled with them. So when the British were there, the British led the provincial reconstruction team that was there and did a phenomenal job. And the British are also in charge of all of the development, partnering with the Iraqis on developing the crime labs, the skill sets in particular. A bunch of nations are contributing money for development. And the boss's comment about Italians, the Italians still lead one of the PRTs also just south of Baghdad. So, I mean, there's just a phenomenal amount of knowledge and training and skill that comes in from all across the world to leverage development in rule of law capabilities in Iraq.
We have some time for questions from the audience, and I believe there's a microphone. Yes, ma'am. Thank you.
Hi, Colonel Bob Ronnie. I'm retired Air Force JAG, and prior to my retirement, I served as a military commissions judge for one of the military commission cases down in Gitmo. I'm familiar with the detention facilities there, and I know there's about, I think last count, 140 some detainees still at Gitmo. Is there any talk of doing the detention review boards? I know the vast majority of those, in my opinion, are probably not going to face any type of judicial action, military commission or otherwise. So is there any talk of doing these detention hearings for some of those detainees down at Gitmo?
Yes, ma'am, and you'll see recently was announced, maybe if you Google, which of course is the easiest way to find information nowadays, but administrative review boards, or ARBs, they're called. So every 6 months there'll be a review. Now the detainees at Gitmo, of course, as you know, ma'am, being there, that they get lawyers down there to help on their habeas petitions, and as well as if their case went before a military commission. But those whose cases haven't been designated yet to go to Article III courts or military commissions, they absolutely are going to have a very set procedures for review. Every 6 months, I'm sorry, I think it's going to actually be every year. And so you'll see some stuff that recently came out in that regard. So the detainees at Guantanamo absolutely continue to get reviews. It's not the old, what was called the CSRTs, perhaps when you were there, Combatant Status Review Tribunals, but now more this administrative review process where there's a lot more procedural rights. Remember, the court was very critical, saying that the CSRTs were inadequate. And so the way that their review is, with the understanding it's going to be like some long-term detention, instead of using the word indefinite detention, which doesn't sound good, long-term detention is absolutely going to be reviewed as we go along. So, great question.
Yes, sir, in the back. Could you wait for the microphone, please? Thank you.
I believe there's no other choice now. A lot of people talk about we're in an era of legally intensive conflicts. There's a lot more attention to human rights, the rights of civilians, and the law of armed conflict than probably in any previous conflict.
I'm not sure how much of that question was directed to me. Certainly, I mean, Supreme Court opinions and everything else that goes on here in the United States has absolutely zero impact on the rule of law mission because we're not incorporating that. My article in general, though, because I really didn't go into, my article looks at how we transition through doctrine for rule of law in general, really Department of State and then Department of Defense. At the direction of the president in about 2004 and 5. So from that, if that's what you're talking about for me, we were definitely in a reactive state. It wasn't because the Department of State wasn't doing their job at all. In fact, the Department of State was proactive in that they were trying to put some new doctrine in place, but that wasn't the position of the United States overall. So then I guess it was reactive because we didn't do a very good job in Iraq from 03 to about 05.
You know, one of the leading experts on that topic, kind of the interplay between the three branches and active action, reaction, Professor Sean Watts. That's his area of expertise. So anything I would say, I'm basically talking about stuff I read that he wrote. So I mean, he's the main, probably one of the leading experts in the country in that area, because a lot of it, I think Professor Watts would agree, a lot of the stuff's been reactive. And I think if early on it wasn't, but there was some concerted effort of the Congress and the President to align things properly with detention operations, probably wouldn't have had a lot of the nightmare situations that we had. But detention ops, just to really answer the question, detention operations in Afghanistan are not reactive to anything. It's still under the authorization for use of military force. How the detainee review boards are obviously the result of a policy, but so it's not going to affect combat operations. And the court's been pretty clear on that. I mean, there's a couple of great comments. It's just the last time I checked, you know, I think it doesn't say it like this, but essentially the last time I checked, there's still active combat going on. You know, what the justice said, again, that's not the direct quote, but there's soldiers in harm's way, and they have to do their job. So,
Time for perhaps one last question, Professor Hansen.
So for Major Rosenblatt, on your article about the deployability of the UCMJ, and is your primary concern that because the UCMJ doesn't seem to be as deployable overseas as the perception it has in the host nation in the area where we're engaging in combat activities, if that is your primary concern, I guess I'm wondering, even if we were to modify the UCMJ to allow more courts-martial in theater, you know, I would suspect that they're going to be in behind a secure area where it's primarily controlled by the U.S., so there's not a lot of interaction between us and the local population, even in that scenario. So I think
Your points are fair, Professor. My biggest concern is I think that we could make it more workable. Right now, the deck is so stacked that the commanders really feel no other choice than sending it back. I especially like your point about the host nation involvement. And one observation I'll make on that is how important it was to Iraq in negotiating, well, they don't call it a SOFA, but in their security agreement. Based on their diplomatic energies and efforts, it was really important for the Iraqis to get the U.S. to commit in that security agreement to trying cases in Iraq whenever possible. And when that wasn't possible, to allow Iraqis who were affected by the crimes to travel to the United States to see the crimes.
One comment, my day job was rule of law. My night job was serving as a trial counsel, which is kind of like an assistant district attorney in prosecuting cases. We had a case that we took down. We could either try them in Baghdad or try them in Kuwait. So I had a jury case, or we call a panel case, in Kuwait. The defense had a material witness that they absolutely had to have, and he had previously been in the service, had since been administratively separated, and was a civilian stateside. Our subpoena power when we're overseas does not allow us to bring a United States citizen forward, certainly not into a combat zone. So what ended up happening was, we lost our motion on the trying to argue that this was not a material witness, but in any event, we lost. And the case was continued for over a month until the defense could finally get with their own witness and get their own witness to stop being difficult with the government so that we could actually bring him over. That's a real world example of the difficulty of trying a cruelty and maltreatment case downrange when the soldier is now gone. He's a civilian, we can't force him to come. He's a material defense witness, and he refuses to sign his passport so we could get him downrange to try this case.
Well, gentlemen, thank you for your invaluable perspectives and for your service.